So he really set 3 different buckets of issues for trial. He saw 3 different controversies. One was about what the nature of marriage was. So the plaintiffs were saying there's a fundamental right to marry that the Constitution guarantees, and that numerous decisions of the Supreme Court have reinforced, whether that's Loving versus Virginia, the interracial marriage case in 1967, or the 1978 cases of Blocky, where individuals were behind in their child payments, child care payments, were still allowed to marry. And then finally, the 1987 case where prisoners were suing for the right to marry. And so they were saying, we deserve the right to marry. And then the other side was saying, well, no, that fundamental right to marry only applies to heterosexual couples because the whole purpose of marriage is to secure or to bind parents to their biological children. So the capacity to procreate internal to the union is a fundamental aspect of marriage. And then the plaintiff said, well, we don't think that that's true. And in fact, when interracial couples or inmates or deadbeat dads were trying to access the right to marriage, they weren't saying we want inmate marriage. They weren't saying we want interracial marriage. They didn't say we want deadbeat dad marriage. What we want is marriage. And so we are just a new group asking for access to an old right. So Von Walker looks at that and says, well, there's a controversy here about what the nature of the institution is. So we're going to set that for trial. And so let's get in a marriage historian, Nancy Cott, who's a preeminent historian of marriage, I think, in this country, to come and testify on the stand. The second bucket had to do with equality and what level of scrutiny or review should be applied to the reasons that were offered for Prop 8 by the proponents. And so under the Equal Protection Clause of the Constitution, which is the home of the equality principle in the Constitution, there are different levels of review or scrutiny. So race gets the highest level of scrutiny, sex gets, meaning gender, gets the second level of scrutiny, and then sort of everything else gets what's known as rational basis review with a very few exceptions. And so Judge Walker says we've never determined at the Supreme Court level whether or not sexual orientation gets heightened scrutiny in the way that race or sex do. And there are 4 factors that the court has told us to look to. And those 4 factors are a history of discrimination, whether or not the group has an equal capacity to contribute to society, whether the group is marked by an immutable characteristic, and whether the group was politically powerless. And there are factual disputes about all 4 of those factors. And so those were also going to be set for trial. And then in the third bucket were the reasons that the state were offering that said, this is not passed with bigotry, which would be unconstitutional under the Equal Protection Clause, or any kind of animus against gay people. Rather, we have really strong secular reasons for wanting to bar same-sex couples from getting married. And those reasons include things like trying to provide the optimal child-rearing scenario for children, which we believe is children being raised by their biological mother and father. And number 2 was we want to prevent heterosexual marriage from being quote-unquote deinstitutionalized, so that if same-sex couples are permitted to get married, that's going to have negative spillover effects on heterosexual marriage in ways that are problematic. And Von Walker, in one of these, again, initial hearings, said to Chuck Cooper, what evidence, for example, do you have on the issue that gay people getting married hurts heterosexual marriage? And Chuck Cooper said, well, we believe that the marriage rate has gone down in the Netherlands since 2001, picking the Netherlands, of course, because the Netherlands was the first jurisdiction in the world to allow same-sex marriages. And, Von Walker, I think quite rightly, Judge Walker said, what is your evidence for that? This is an empirical statement that you're making to the court. It's not a theoretical statement. And Cooper said, I haven't come in today with a presentation on that. And at that point, Judge Walker said, this needs to be set for trial as well. So basically, all 3 of those buckets, what is the nature of marriage? What is the nature of gay people? And do they deserve heightened scrutiny based on their characteristics? And then finally, has the state offered justifications that are not religious and not based on animus, right, to justify this ban on same-sex marriage? So all 3 of those buckets contained issues of fact and what in the law are known as genuine disputes over material facts such that the case, in the judge's view, had to go to trial. It wasn't just that this was a kind of nice to have. It was that there was enough factual conflict and evidentiary conflict that this case needed to go to trial.